welcome to everybody. So today I want to talk about the Supreme Court in the 1950s and 60s, the court under Earl Warren. It is the first and so far only time that the Supreme Court was more liberal than the rest of the country, mainstream public opinion, people in Congress. The justices were seriously liberal by the standards of the day. And the man setting the tone was Earl Warren. He grew up in a very poor working class family. His parents were first-generation immigrants from Scandinavia. His father was a labor organizer who got blackballed in the 1890s. Warren's complete name was Earl Warren, and he liked to joke that his parents were so poor that they could not afford a middle name for him. He was not a particularly distinguished scholar. When he was at law school, the dean advised him to find another line of work. But he stuck with it. After law school, he became a public prosecutor in Oakland. He was then elected Attorney General in the state of California. After that, in 1942, he was elected governor of California. And as governor, he supported the rounding up and interning of the Japanese Americans on the West Coast. He later apologized and said basically it was the worst mistake of his public career to have supported that. But at the time, he did what most politicians in California would have done. As governor of California, he helped Dwight Eisenhower get the Republican nomination for president. And, political favoritism, or favors being what they are, Eisenhower promised him the next seat on the Supreme Court. Eisenhower did not expect that seat would be for Chief Justice, but when the Chief Justice, Fred Vinson, died in 1953, Eisenhower honored his promise. One reporter commented that, again, Warren was no scholar. One reporter commented that Warren had, quote, probably never bothered with abstract thought twice in his life. He cared a lot less about what the legal doctrines of the Constitution were and much more about what would be fair. His favorite question to lawyers at oral argument is whether a particular result would be just. Supporting him, the two of the other prominent liberals on the court were Hugo Black on the left of the slide and William O. Douglas on the right. Both of them had been nominated by Franklin Roosevelt. Hugo Black had been a senator from Alabama and a loyal supporter of the New Deal. Shortly after Roosevelt nominated him, the press revealed that Black had been a member of the Ku Klux Klan early in his political career. Back in the 20s in Alabama, it was pretty much a requirement to run for public office to have been a member of the Klan. Despite there was backlash against that, but Roosevelt stuck with the nomination. Black went on to have a very distinguished career on the court. He truly believed in applying the Bill of Rights, the letter and law of the Bill of Rights. He was committed to it. William O. Douglas grew up poor in Washington State. When he hitchhiked from the West Coast to New York for law school with only pennies in his pocket, worked his way up in various New Deal agencies. At one point, he was the chair of the Securities and Exchange Commission. He was also one of Franklin Roosevelt's poker pals, lots of late-night poker sessions at the White House. And at one point, Roosevelt said to him, I want to offer you a job that you'll detest. And that is, quote, something like being in jail. And what he meant was a seat on the Supreme Court, which Douglas actually didn't like very much, but he stuck with it for years and years. The associate appointed a little bit later that became Warren's primary assistant was William Brennan. Brennan was a labor lawyer in Newark, New Jersey, and then a state court judge. Curious, politics was maybe a little different back then. It was 1956, it was an election year, and President Eisenhower decided that he wanted to make an appointment of a Catholic Democrat. He wanted to, lure Catholic voters, and he wanted to show that he was nonpartisan and reach out, to the Catholics and the Democrats in the country. So he asked his Attorney General to recommend somebody, and the Attorney General recommended Brennan. Eisenhower's interview with Brennan lasted 20 minutes and did not concern the law. I'm not sure what they talked about, but they didn't talk about the Constitution. It was a different era back then, apparently. Brennan became Warren's right-hand man and chief tactician. They voted together over 90% of the time. Brennan liked to say, he'd say, what's the most important number at the Supreme Court? And then Brennan would hold up his hand and say, 5. With 5 votes, you can do anything around here. A few years later, somebody asked Eisenhower if he had made any mistakes while he was president, and he said 2, and they're both sitting on the Supreme Court. So you had 4, between Warren, Brennan, Black, and Douglas, you had 4 consistent liberal votes, and then the big change happened in 1962 when Felix Frankfurter retired, and John F. Kennedy chose Arthur Goldberg, he's on the left on that slide, Goldberg to be the justice. Goldberg had quite an amazing success story. His father was a Russian immigrant fruit peddler. Goldberg was the 11th son in the family, somehow worked his way through college and law school, then became a lawyer for the AFL-CIO. After he'd been on the court for a few years, Lyndon Johnson pressured him into resigning and becoming the American ambassador to the UN. And Johnson replaced him with Abe Fortas, who's the fellow on the right on that slide. Fortas had been Johnson's lawyer and advisor since the early 50s. So Fortas replaced Goldberg as a consistent 5th vote. Not every case that gets to the Supreme Court has a sort of political dimension. Some of it's just cut and dried, and how do you interpret a statute? But on the ones that had political ramifications, you now had consistently 5 liberal votes, became 6 after Johnson appointed Thurgood Marshall in 1967. As I've talked about it in an earlier lecture, Marshall was the architect of the NAACP's legal strategy for tackling segregation. In 1965, Lyndon Johnson named Marshall to be the Solicitor General, which is the position at the Justice Department, the person who goes into the Supreme Court and argues on behalf of the government in all the important cases. Johnson told Marshall he wanted the nation to see a black man representing the government in front of the Supreme Court. Marshall appeared before the court more than 30 times and had quite a good track record. And then in '67, Johnson appointed Marshall himself to the court. So here they are. I don't know how, this is the court in 1968. In the back row there, you've got Abe Fortas, a fellow named Potter Stewart, one of the more conservative justices at the time, Byron White, third from the left, appointed by Kennedy, liberal on some issues, conservative on others, and then Marshall. In the front, you have John Marshall Harlan, who was the primary conservative writing dissents. The poor man dissented an awful lot during the 1960s because there were so many things they were doing that he didn't agree with. And then you have Black, Warren in the center, Douglas, and on the far right you have Brennan. Okay, so, and by the way, I do want to apologize. There are no songs in today's lecture. I know, it was fun last time. I admit, but I couldn't think of a clever video or song to go with this. Even Diana Ross and the Supremes, I don't know, I just couldn't quite do it. So, anyway, I apologize. All right, so let's do a little quick recap about the Constitution and some parts of it that matter for today's purposes. The Bill of Rights. Okay, remember the Bill of Rights? There are the basic ones, the first 5. I needed 2 slides to cover them all. The people who first drafted the Constitution way back in 1787 didn't think we needed a Bill of Rights. It was the opponents of the proposed Constitution who were very concerned that it didn't have enough protections for individual liberties. And as part of the ratification process, the people supporting the Constitution agreed to pursue amendments, and the first Congress drafted the first 10 amendments. So, freedom of speech. Oh, stop doing that. There we go. There's one you've probably never thought about. The Third Amendment protects you from having the Army make people, force you to have soldiers sleep on your sofa. Something that was a colonial era issue, but all right, so most of the amendments involve protections for criminal defendants. No unreasonable searches and seizures. They can't take your liberty or life, liberty, or property without due process. And then some other protections for criminal defendants. And I'm going to come back to some of these a little later. But yeah, all right, hold on, one more thing. And then the 14th Amendment. The 14th Amendment was passed, this is the other critical amendment for so much of what the Warren Court was doing. It was passed after the Civil War, and the first thing it did was to provide that everybody born in this country is automatically a citizen. I mentioned it during, I think, back on the lecture about the civil rights. The idea was that to negate a Supreme Court decision from before the Civil War that said black people could never be citizens, the 14th Amendment first says if you're born here, regardless of where your parents came from, you're a citizen. It's something that's quite a target in the news today because President Trump is trying to get rid of that and have them read it a different way. And then the two key parts of the 14th Amendment: the states cannot deprive anyone of life, liberty, or property without due process of law, and the states cannot deny to anybody in their jurisdiction equal protection of the laws. Very wonderful language, very broad. I hate to let you in on, well, no, I do. I actually do want to let you in on this secret. There are no right ways to interpret the Constitution. There are no right answers. These terms don't have official definitions. The definitions have evolved over time. I'm a crazy person. I actually wrote a book, which you can find on Amazon, about how they're making it up as they go along. And they have been. And it's fascinating to see the different stories that the justices have been telling over the decades about what these terms mean. So how did the Warren Court apply some of this language? First of all, they were consistently supporting the civil rights movement, beginning with the landmark case of Brown versus Board of Education. And I mentioned this during the class on the civil rights movement at the beginning. When the case first got to the court and the justices first took a vote, they were split 5-4 on what to do about integrating public schools in the South. 5 of them wanted to get rid of the separate but equal doctrine. 4 of them did not. And one of the ones who did not was the Chief Justice, Fred Vinson, who came from Kentucky, where everything was segregated. Then, in the fall of '53, Vinson died, Warren steps in, and Warren knew that they had to somehow come up with a decision that would be unanimous. If it wasn't unanimous, it would be such a signal to the South that they could ignore it or fight back. And so he lobbied intensely. The 3 holdouts after Vinson died, there were still 3 who didn't want to. He lobbied with them, eventually was able to produce a unanimous decision that the idea of separate but equal does not apply in the context of public schools. It's inherently unequal. Now, how else did the Supreme Court help the civil rights movement? In one important case, they protected the NAACP from persecution by southern states. After the Montgomery bus boycott, in which the NAACP played an active role, the Alabama Attorney General, there he is, John Patterson, tried to shut down the NAACP in the state of Alabama. And like most states, Alabama had a law that said out-of-state organizations have to register before they can do business in the state. Perfectly standard law. It applies in all sorts of settings. The NAACP had never registered in Alabama because they didn't consider that they did business there. They were just an advocacy group. They weren't they weren't selling things, they weren't marketing things. So they had never registered. A white judge issued an order that the NAACP stop everything it was doing in Alabama. And the judge also ordered that the NAACP had to produce a list of every single member in the state of Alabama. And everybody knew that if the names became public, the people on that list were going to be harassed, maybe physically attacked, but certainly persecuted in an economic sense. People would lose their loans, all kinds, there would be retaliation of all sorts. Ooh, that's an ominous sound. That was cool, let's not do that. Okay, so they didn't produce the list. They produced all the other documents. They didn't produce the list. The judge held the NAACP in contempt and fined them $100,000, which is a lot of money back then. The justices unanimously vacated the contempt order, and John Marshall Harlan wrote that the freedom to join with other people is an inseparable aspect of the liberty that due process protects. I mean, what does liberty mean? In this setting, it means all kinds of different things, and one of them is that you get to join with other people and pursue causes that the group of you think are important. And forced disclosure of the membership list would discourage people from joining and participating. And so Harlan said that the First Amendment and the 14th Amendment say the state can't do that. Another context for protecting the civil rights movement involved protests. If you remember, starting in 1960 with the sit-in at the Woolworth's lunch counter in Greensboro, North Carolina, there was a wave of sit-ins and protests against segregation across the South. The local police often arrested people who were part of the protests. One of the cases involved a demonstration by hundreds of black students at the State House in Columbia, South Carolina. There's a couple of photos of them marching. The police gave them a 15-minute warning, and when they didn't disperse, the police arrested 200 marchers. And what had they been doing? They'd been singing the Star-Spangled Banner. They were perfectly orderly, but they were charged with breach of the peace. They were convicted and sentenced to 30 days in jail. The justices tossed out those convictions, and Potter Stewart wrote that demonstrating is an exercise of basic constitutional rights in their most pristine and classic form. And then he continued, the Constitution does not permit a state to make criminal the peaceful expression of unpopular views. I mean, if you can't protest peacefully, what is the First Amendment for? That's really what it came down to. Then the Congress passed two landmark civil rights laws in the mid-'60s, and of course there were legal challenges. First, you have the Civil Rights Act of 1964, prohibiting discrimination in all sorts of what were called public accommodations, hotels, restaurants, theaters, parks. And the question, is an interesting question, is where does Congress get the power to prohibit discrimination? If you look at Congress can only do what the Constitution spells out it can do. Congress can't just do anything it thinks of, although sometimes it looks that way. But it's only allowed to exercise specific powers listed in Article 1. And so the question was, what is Congress doing? What power is it using to prohibit segregation and discrimination in public places? And the answer was they relied on the Commerce Clause. And here's the two big test cases came along. One involved the Heart of Atlanta Motel. It's on the lower left there. It's not there anymore, but that's a photo of it. It was a 200-room hotel right near Interstate 75 and 85 in downtown Atlanta, and it refused to rent rooms to black people. Standard practice in the South at the time. The other test case involved Ollie's Barbecue. There's Ollie McClung there on the upper right. He had a 200-seat restaurant in Birmingham, Alabama, and his restaurant only served black people at the takeout counter. White people could sit down, black people had to stand around on the side at the takeout counter. The justices ruled that discrimination like that interferes with commerce because people, black people aren't free to go where they want and buy the things that they want in commerce because of the restrictions. And so the discrimination is an obstruction of interstate commerce that Congress has the power to remove. That was the theory, and it's part of a broad interpretation of the Commerce Clause that Congress has used in all sorts of settings over the last several decades. The other big landmark civil rights law was the Voting Rights Act of 1965. And I've flagged a couple, I talked about it before and flagged a couple of things on the slide there. Naturally, southern states filed lawsuits to prevent the Justice Department from enforcing it. And in 1966, the justices said that Congress had the power to regulate voting in the way that it did. And in doing so, what power is Congress exercising here? The 15th Amendment, another one passed after the Civil War that says that you can't discriminate in voting on the basis of race. And the amendment includes a provision, which I've quoted on the slide, that Congress can enforce this amendment through appropriate legislation. And it treated the Voting Rights Act, as the justices did, as one example of what Congress can do to enforce the 15th Amendment. Now, that's sort of big-scale legislation that involves a lot of people, but the Civil Rights Act and the Civil Rights issue and the Constitution also involve ordinary people who fall in love. And during the 1950s, 90% of white Americans believed that marriage between black and white people should be illegal. Richard Loving, and that fellow was white. Mildred Jeter was part black and part Cherokee. They grew up in a small town in Virginia. They fell in love. They could not get married in Virginia, so they moved to Washington, D.C. in 1958 and got married. Sometime afterwards, they decided they wanted to move back to their home state of Virginia, so they did. Within just a few weeks, the police raided their home because, of course, they'd been tipped off. Loving and Jeter were sentenced to 1 year in jail. But the sentence was suspended as long as they left Virginia and never came back. This is what the state court judge said. Almighty God created the races white, black, yellow, and red, and he placed them on separate continents. The fact that he separated the races shows that he did not intend for the races to mix. That wasn't 1852, that was 1962 or thereabouts, a state judge in Virginia. So they did leave the state of Virginia. They moved to Washington for several years, and then they asked the ACLU to help them get the conviction vacated in Virginia. By that point, there were still, this is 1967, there were still 16 states that made interracial marriage illegal. The justices struck down the law. Warren relied on the Equal Protection Clause. He also relied on the Due Process Clause. And he said that the freedom to marry is fundamental to our very existence and survival, and has long been recognized as one of the vital personal rights essential to the orderly pursuit of happiness by free people. The language, first of all, what a great case to be, the Loving case. I mean, it doesn't get better than that, really. And it was Warren's language in this opinion was front and center when the issue of gay marriage came up in the early 2000s. Because what logic distinguished telling that group of people they couldn't get married when you have a clear decision that this other group, of course they can get married. It's not the state's business. Okay, switching topics. Two of the Warren Court's most important decisions revolutionized the way state governments operate in this country. And so to try to illustrate it as best I can, that's a map of the Senate districts for the Massachusetts legislature. So, you got to have districts, you got to have boundaries. state constitutions typically require that legislative districts get redrawn every 10 years to allow for the fact that people move. But in 1960, when Warren took over, many states had not redrawn their lines since 1900. And if you go back you go back to 1900, there weren't people living in the suburbs, and there weren't nearly as many people living in the cities. And what you had was a very, well, I'll put it this way. The result of not reapportioning every 10 years is you get an enormous imbalance between where the votes are and where the people live. Some examples. In California, by the early 60s, one state senator represented 6 million people in Los Angeles, and one state senator represented 3 counties in the Sierra Nevadas that had 14,000 people. In Vermont, the largest district was Burlington. It had 33,000 people. The smallest district had 238, and each of them elected one representative. In Alabama, Mobile, the city of Mobile, with 104,000 people, had one representative, and there were rural counties with 7,000 people who had one representative. In Florida, it only took 15% of the population to elect a majority of the legislature. Okay, I mean, so think about it. So if you're living in the cities or the suburbs, your vote is not counted equally. The rural districts have the ability to outvote you big time. So there were legal challenges. And the first issue was, is this even something that the Supreme Court can handle? And there were cases that had been around for a while that suggested that some issues are just too political for the Supreme Court to get involved with. In Baker versus Carr, the justices said no, the Constitution applies to something like this kind of districting, and it opened the door to hearing on the merits. And then 2 years later, in Reynolds v. Sims, they did rule on the merits and adopted the one person, one vote principle. And Warren used some good examples. You can't give. Suppose you just gave men 3 votes and women only had 1. That couldn't be fair, right? But to give people in a rural district 3 times the voting power of people in the suburbs, how is that fair? How do you justify that? And the justices couldn't justify that. As Earl Warren put it, the right to vote freely for the candidate of one's choice is of the essence of a democratic society. Restrictions on that right strike at the heart of representative government. And the idea that somehow rural districts are important and you need to kind of boost their political power, Warren wasn't buying it. As he put it in his opinion, legislators represent people, not acres or trees. Legislators are elected by voters, not elected by farms or economic interests. So, up until then, if you think about it, virtually every state in the country had to redo their boundaries to bring their legislatures in line with the one person, one vote rule. This is a revolution. And late in his career, when they asked Warren what he was most proud of all the things that his court had done, this is what he pointed to, because it really brought democratic government to the states and to ordinary people in a way that just they hadn't had. Okay, another example of applying the Constitution in the area of the political process involved the poll tax. Ever since the colonial era, it used to be the case that if you wanted to vote, you had to pay for it. You had to pay a little fee. Most states dropped them over the course of the 19th and 20th century, but in the early 60s, there were still 4 states that had them. Virginia required everybody to pay $1.50 if they wanted to vote. Now, that's not a lot of money, but it's the principle of the thing. And Annie Harper and several other poor black people in Virginia hired a lawyer, it's Joseph Jordan there sitting in the chair, to bring a challenge on behalf of the poor people of Virginia. And the courts relied on the Equal Protection Clause to strike down the poll tax. As William O. Douglas wrote, Wealth, just like race or creed or color, is not germane to one's ability to participate intelligently in the electoral process. To introduce wealth or payment of a fee as a measure of a voter's qualifications is to introduce a capricious or irrelevant factor. And again, it's the principle. I mean, $1.50 doesn't seem like much, but on the other hand, why should you have to pay it all? And that's what they concluded. Now, many of the most important decisions that the Warren Court issued involve the First Amendment. Let's remind ourselves briefly what the First Amendment does. Congress cannot pass a law respecting an establishment of religion. Congress can't prohibit someone's free exercise of religion. And then Congress can't abridge freedom of speech, freedom of the press, and the right to assemble. Now, on the face of it, the First Amendment only applies to Congress. But here's an example of how the Supreme Court, in its infinite wisdom, has been making things up as it goes along. Because over the course of the 20th century, the Supreme Court has, in one setting after another, concluded that the amendments ought to apply to the states. And it started doing that with the First Amendment back in the early 20th century. So even though this says Congress can't do that, there was precedent for the idea that the states can't do this either. And the states can't, for example, have an established religion. So how did this come up in the 60s? Little kids praying in public school. Does that look familiar? Any of your kids there? I might have been there. It was in 1960, it was extremely common for public schools to start the day with an official religious service of some form or another. In Pennsylvania, the school started with a reading from the Bible. Everybody had a particular verse that the teacher had to read. In Maryland, the school started with everybody reciting the Lord's Prayer, the Our Father. The New York State Regents, the Board of Regents, drafted their very own prayer for all the schools in New York, all those kids. So every morning, all the kids in New York had to say, "Almighty God, we acknowledge our dependence upon Thee, and we beg Thy blessings upon us, our parents, our teachers, and our country." Very, very standard thing. Now, is that an establishment of religion? Yeah, I think you could kind of say that. And so, in two cases, in 1962 and 1963, the Warren Court justices ruled that those mandatory exercises in public schools violated the Establishment Clause. Justice Black offered a kind of a history lesson, and it was interesting. He said he talked about how the early colonists, that came over from England, they wanted to leave the official church of England behind, but then somehow when they got here, they ended up making the same mistake. And because the colonists created official churches here, the Puritans in New England were the official church. Your taxes went to support the ministers in the Puritan New England. So somehow, so the colonists sort of lost their way, but then the founding fathers realized that, as Black put it, one of the greatest dangers to the freedom of the individual to worship in his own way lies in the government placing its official stamp of approval upon one particular kind of prayer. And then he also said that basically because the Establishment Clause teaches us that religion is too personal, too sacred, and too holy to be dictated by the government. These decisions were among the most controversial that the Warren Court ever issued, and there are still people who have been hoping the Supreme Court will reverse them. Cardinal Francis Spellman said that these decisions strike at the very heart of the godly tradition in which America's children have so long been raised. Theologian Reinhold Niebuhr, some of you may know that name, he was one of the most prominent, well-respected theologians in the country at the time. I think he overreacted. He said that these decisions practically suppress all religion, especially in the public schools. Congressman George Andrews of Alabama complained that the justices have put the Negroes in the schools and then they've driven God out. Okay. But at the time, 80% of American adults thought these official prayers in public schools were okay. The Warren Court was way out ahead of public opinion on this one. Congressmen introduced 100 proposed amendments over the next several years to reverse these decisions, but they never got through Congress. Now, what's another way that the state can interfere with someone's religion? On the Establishment Clause, the Free Exercise Clause, the key case involves this woman, Adele Sherbert. Adele Sherbert was a member of the Seventh-day Adventists. It's a millenarian Protestant denomination, and the way they read the Bible, Saturday, not Sunday, is the official Sabbath and the day of rest. Ms. Sherbert worked at a textile mill in Spartanburg, South Carolina. The mill adopted a new shift schedule that required her to work on Saturdays. She refused, and they fired her. She couldn't get a new job that didn't require her to work on Saturdays. And so she filed for unemployment in the state of South Carolina. But under South Carolina law, people aren't eligible for unemployment benefits if they refuse to accept available, suitable work without good cause. And the folks at the South Carolina Department of Unemployment Benefits decided that her religious beliefs were not a good reason to not work on Saturdays. So they denied her unemployment. The justices ruled that that was an interference with the free exercise of her religion. And Brennan's opinion is very interesting because there are two competing kind of principles here. The state has to be able to punish dangerous conduct, even if it's motivated by religious belief, right? I mean, we can't have child sacrifice ceremonies in this country, even if they're motivated by some form of religion, right? That would not be acceptable. Well, I shouldn't speak for you, but chances are people aren't going to go for that. On the other hand, you can't just punish people anytime what they want to do violates or contradicts the majority's view of what's acceptable. So you have to have a balance. Some things the state has to be able to prohibit, even if religion is involved, but that has to be a small category. And Brennan concluded, and the justices concluded, that South Carolina didn't have a good enough reason to punish Adele Sherbert just because she didn't want to work on Saturdays, because her view of God told her she shouldn't work on Saturdays. Okay, what else? The First Amendment. In the area of pursuing communists, if you remember, Warren took over at the peak of the McCarthy era. Just a few years earlier, the Supreme Court had upheld the conviction of Eugene Dennis and the other leaders of the Communist Party in America. There was no evidence that they had actively done anything to try to overthrow the government of the United States. Their convictions rest, basically when the government went to prove its case against Dennis and his defendants, they just read an awful lot from Marx and Lenin about how overthrowing capitalism is a good thing. And that's part of communist teaching. So the conviction essentially rested on their beliefs, not the fact that they'd actually done anything to try to overthrow the government. The Warren Court justices took a different approach and issued 3 decisions in 1957, all tossing out convictions and other penalties against supposed subversives. And critics of the decisions were so upset they referred to the day the decisions came out as Red Monday. One of the cases involved the fellow on the left testifying, John Watkins. He was brought before the House Un-American Activities Committee. He actually answered questions about his own involvement in the Communist Party, but he refused to answer questions about other people and whether they had been involved in the Communist Party. So he was convicted of refusing to testify and locked up for a year. The woman in the center, Oleta Yates, she and other Communist Party members were prosecuted they published the Daily Worker, it's the communist newspaper. They were convicted of advocating the overthrow of the government. They were sentenced to 5 years. The fellow on the right is Paul Sweezy, who at the time was the nation's best-known Marxist economist. New Hampshire was investigating subversive people. He refused to testify about lectures on Marxism that he had been giving, and he refused to testify about his membership in various left-wing political groups. So a judge held him in contempt. The justices tossed out all of those rulings, or all those orders. And they basically concluded you can't punish somebody just for advocating communism in the abstract. They've got to be actually trying to do something illegal and dangerous right now. And the leaders of the Communist Party weren't doing anything like that. They were just talking. And after these decisions, the Justice Department basically gave up trying to prosecute suspected communists. These decisions outraged so many people that the John Birch Society, which was a new group at the time, started putting up billboards all over rural parts of America, impeach Earl Warren. Billboards, bumper stickers, and conservatives flooded Congress with angry letters about what the Supreme Court was doing. There were laws or proposals to somehow take away the court's power to rule in cases like this, but they didn't get anywhere. Now, as I mentioned a few moments ago, the justices ruled that you can't punish people for peaceful protests and demonstrations, and they even extended that to students in school. In December 1965, a group of parents and school children in Des Moines decided to express their opposition to the Vietnam War by wearing black armbands. The school district announced that any student wearing a black armband would be suspended. 5 of the students wore black armbands anyway, and they got suspended. The father of Mary Beth and John Tinker, there they are with their armbands. Their dad, they got suspended, so their dad sued the school district. And Abe Fortas, writing for the court, announced that students and teachers do not shed their constitutional rights at the schoolhouse gate. And he may have been overreacting a little bit here, but Fortas wrote that state-operated schools may not be enclaves of totalitarianism. That might be overdoing it. But the point is, wearing a black armband was a protected form of speech. It was signaling your opposition to the war. And just because the school district has said, well, good Lord, people are wearing black armbands, there might be fighting in the halls, there might be disorder and turmoil. And Fortas wrote that anything might cause trouble. Any word spoken in class or on the lunchroom or on the campus that deviates from the views of another person might start an argument, might cause a disturbance, but the Constitution says we have to take the risk. Now, not everybody agreed. Hugo Black, at this point, Hugo Black was starting to worry that students running amok with black armbands was a sign that civilization was in danger. And he wrote in his dissent that this decision was the beginning of a new revolutionary era of permissiveness in this country, fostered by the judiciary. But he was in the minority on that one. So the Warren Court justices were tolerant of peaceful protest, but they did draw the line at draft card burning. Federal law made it a crime to knowingly destroy or mutilate a draft card. David O'Brien, he's in the center of that photo there, he and some of his friends burned their draft cards during a demonstration on the steps of a Boston courthouse, clearly intended to express opposition to the war. O'Brien was convicted and sentenced to 6 years. The justices affirmed this one. And Warren wrote that the government, yes, O'Brien was trying to express his opposition to the war, but he had other ways he could have done that, and the government has a legitimate interest in making sure that the draft functions properly, and the Army is able to get the people it needs, and making it criminal to destroy your draft card is essential to the process of that, the functioning of the draft law. So the government has a legitimate interest, and if O'Brien wanted to protest He should have done something different, but he stayed in jail. Okay. One of the landmark decisions on the First Amendment involves when the press can be held liable for defaming a public official. The key case here is New York Times versus Sullivan. This actually, again, does arise from the civil rights movement. Back in the era of the sit-ins at the early 60s, black celebrities, Nat King Cole, Sammy Davis Jr., and Jackie Robinson paid for a full-page ad in the New York Times calling attention to the fact that people were getting locked up for peaceful protests down in the South. They needed money to pay lawyers, and it was a kind of a, please notice what's happening and please contribute to help. So there's this full-page ad in the Times. There were a few very, very small factual errors in the full-page ad. The sheriff in Montgomery, the ad referred to the arrest of people at a demonstration in Montgomery, Alabama. The sheriff, named L.B. Sullivan, he sued the Times for libel. And the only defense under Alabama law was that the article was 100% accurate, which it was not. A white jury awarded $500,000 in damages, even though Sullivan offered no evidence that his reputation had been hurt. And even though the Times, they printed 650,000 copies a day, and only 400 of them got sold in Alabama. Nevertheless, $500,000, which was a lot back then. The justices said no. The nation, as Brennan put it, there is a profound national commitment to the principle that debate on public issues should be uninhibited, robust, and wide open. So yes, public officials do have an interest in protecting their reputation, but the importance of free public debate about matters of public interest is such that we need to strike a balance, and the way the court came up with it was the public official can only prevail if the newspaper prints a false story with actual malice, which means the newspaper knows the story's false or they recklessly don't care if it's false. The actual malice standard is a tough one, and public officials rarely are able to prove that a newspaper like the Times crossed that particular line. Now, a different kind of First Amendment problem is what do you do with obscenity? Does the First Amendment apply to obscenity? In 1957, the justices upheld a couple of convictions for obscenity. One of the fellows was Samuel Roth. I mean, that guy doesn't look like a threat to public morals, does he? But there he is, and he published American Aphrodite, which was a monthly with erotica and nude photos in it. The other defendant was David Alberts. I couldn't find a picture of him, but he had a mail order business and he sold nude pictures. So, what does the First Amendment protect this? Brennan wrote that the First Amendment was intended to protect the unfettered exchange of ideas about political and social issues. Obscenity is, quote, utterly without redeeming social importance and gets no protection. But on the other hand, what does that mean? Does that mean anytime somebody mentions sex, it's by definition obscene and illegal? Brennan didn't want to go that far. So he adopted a test. It's obscene if, to the average person applying contemporary community standards, the dominant theme of the material, taken as a whole, appeals to the prurient interest. P-R-U-R-I-E-N-T, prurient, a word you never see anywhere else and which, as far as I know, nobody has ever defined. Nobody knew what it meant. For the rest of the decade, the Supreme Court heard dozens of cases about obscenity and could not agree on what they were doing. Potter Stewart said he didn't care about the definition because, direct quote, yes, he's the source, Potter Stewart, I know it when I see it. It's got to be one of the few remarks ever made by a Supreme Court justice that has now common, that we use it all over the place. I know it when I see it. The justices had to set up a projector in the basement so they could watch films that were being prosecuted by, district attorneys around the country. When John Marshall Harlan's vision started to fail, he had Potter Stewart narrate the movies for him. So Stewart would be whispering what's going on screen, and Harlan would be saying, "My God, that's extraordinary." Brennan threw up his hands and was heard to say, "I am sick and tired of seeing all this goddamn shit." And Earl Warren was so prudish, he refused to watch any of the movies. But they couldn't decide. At the same time, the utterly without redeeming social importance standard ended up being used by courts to lift bans on things that, yes, they talk about sex, but they do have social value. I mean, it was illegal to sell James Joyce or Lady Chatterley's Lover. Ulysses and Lady Chatterley's Lover were banned books, literally, in places not just in Boston. Courts start overturning bans on literature like that, using the language from the Supreme Court decisions. Now, in one of these cases, in one case involving obscenity, the justices did actually manage to agree. The case involved a fellow named Robert Stanley. The police searched his home. They were looking for evidence of gambling activities. They didn't find that, but they did find 3 reels of 8mm film. "Well," said the officers, "I wonder what this is." So the officers locate Stanley's projector. They sit down to watch the movies, and then they arrest him for possessing obscene materials. The justices tossed out that conviction. And Thurgood Marshall wrote, if the First Amendment means anything, it means that a state has no business telling a man sitting alone in his own home what books he may read or what films he may watch. Our whole constitutional heritage rebels at the thought of giving government the power to control men's minds. This is one of the first big cases to recognize the concept of a right to privacy, which I'm going to come back to in a few minutes. All right. One of the areas where the Warren Court did the most to change the rules involved the criminal justice system in the country. And as I mentioned, on the face of it, the Bill of Rights doesn't apply to the states, but in case after case, the justices continued a process of applying the Bill of Rights to the states. And so, I won't identify all the separate cases for this part of things, but the idea that the state can't prosecute you twice for the same offense, double jeopardy, the privilege against self-incrimination. There was a case where a fellow had been charged with some serious crimes. He had such a long track record that he decided not to take the stand in his own defense. So the prosecutor says, if Mr. Griffin really were innocent, he would have taken the stand and told you so, but he didn't, did he? And then the judge said to the jury, you can draw an inference about the fact that Mr. Griffin did not take the stand. The justices said, no, you have a right to be silent, and the prosecution and the judge can't take advantage of that and sort of encourage the jury to convict you because of the fact that you were silent. The Sixth Amendment assures you of the right to a speedy trial. The government can't just rely on statements by witnesses who aren't there. They have to bring the witnesses into the courtroom so that you can cross-examine them. You have a right to a jury trial. These cases are interesting, but they weren't front-page news in the same way that the next 3 cases were that I want to talk about. So first, the first really big front-page news decision by the Warren Court in this area involved Dalray Mapp. There she is. 7 policemen came to her home looking for her boyfriend, who was a suspect in a gambling racket. She refused to let them in because they didn't have a warrant, so they kicked down the door. They came in. They didn't find the boyfriend. They didn't find any evidence of the gambling, but they did find some lewd and obscene photos, which she said had been left behind by the previous owner of the apartment. But, whether you believe that one. Anyway, so this was and she was convicted of possessing obscene materials and sentenced to 1 year in jail. Now, this is a clear violation of the Fourth Amendment. It was an illegal search. But the question is, what do you do about it? What's the penalty if the police don't follow the rules? And there was actually not a clear line in this area until this decision, when the justices ruled the only effective remedy if the police break the rules and conduct an illegal search is to keep out any evidence that they take. It can't be used at trial. As the Justice Tom Clark put it, nothing can destroy a government more quickly than its failure to observe its own laws. The exclusionary rule. Conservatives have been trying to get rid of this for ever since, and it's still on the books with some exceptions, but it's still there. The only one of these decisions that was truly popular at the time involved Clarence Gideon. There he is. He was charged with breaking and entering a Florida pool room. Mr. Gideon had quite a rap sheet. He was 50 years old, and he had spent 17 years behind bars for various robberies and other felonies. So he's been charged with breaking and entering. He tells the judge he can't afford an attorney. He tells the judge that under the Sixth Amendment, the state has to provide him with an attorney. The judge says no, Florida doesn't do that. So Gideon said he was innocent. He defended himself, but he got convicted and sentenced to 5 years. While in prison, he writes that petition in hand and mails it to the Supreme Court, saying that my trial violated the Sixth Amendment. And the justices decide to hear his case. And they ruled unanimously that a state has to provide an attorney for an indigent defendant accused of a felony. As Hugo Black wrote, in our adversary system of criminal justice, any person hauled into court who is too poor to hire a lawyer can't be assured of a fair trial unless counsel is provided for him. This seems to us to be an obvious truth. So, there's a second trial. Gideon has a court-appointed lawyer, and he gets acquitted. And, you could say, we'll never know for sure, but he may have served 2 years in jail for a crime that he had not committed. The third of these, the three big decisions in the mid-'60s involved Ernesto Miranda. Miranda was convicted of kidnapping and raping a teenage girl. The evidence was circumstantial. The poor girl didn't see the man's face. She couldn't identify him, but there was a witness who claimed that they saw Miranda's car in the vicinity of where the crime took place. Miranda was questioned for 2 hours at the police station. They never told him he had a right to talk to an attorney. They questioned him for 2 hours. We'll never know exactly what kind of pressure they put on him, but after 2 hours, he signed a written confession. And then he argued on appeal that the conviction should be set aside because he should have been told that he had a right to talk to an attorney. At the oral argument, the lawyer for Arizona foolishly suggested to the justices that they really shouldn't encourage, this was the word he used, encourage suspects to consult with lawyers. Earl Warren looks the guy straight in the face and says, "Are lawyers a menace?" But actually, in this context, the lawyers were perceived as a menace. Warren's opinion is really quite interesting. He'd been a district attorney. He'd been an attorney general. He knew a lot about law enforcement. And he describes all sorts of examples of police brutality. He quotes from police training manuals about how you get the suspect alone, you literally and psychologically beat on them until they confess. They were teaching the police how to get confessions out of people by isolating them and intimidating them, and he knew that sadly in a lot of police stations, bad things happen. And the whole system benefits if there's a confession, right? They don't have to waste time on a trial. The guy goes straight to jail. We can go on to the next case. There's a lot of incentive to get confessions. And most of the people were probably guilty, but not everybody. And so Warren's decision stands for the proposition that the suspect's right to decide whether to talk to a lawyer has to be protected, and the way to do that is the police have to give warnings. And we can all recite the warnings, right? Because they're now standard in every movie and TV show that you see about police stations.
You have the right to remain silent. Anything you say can and will be used against you in a court of law. You have the right to an attorney, and if you cannot afford an attorney, one will be provided for you. Warren pointed out that the FBI had been using warnings like that for years and years, and it didn't seem as if the FBI was having trouble continuing to investigate and arrest people and develop cases against them and get them convicted. He was trying to sort of head off the criticism that was sure to follow. And some of that criticism came from some of his fellow justices. John Marshall Harlan was outraged at this decision, and he wrote in his dissent, "The court is taking a real risk with society's welfare in imposing this new regime on the country. The social costs of crime are too great to call these new rules anything but a hazardous experiment." Byron White wrote, in some unknown number of cases, the court's rule will return a killer, a rapist, or other criminal to the streets to repeat his crime whenever it pleases him. And they were right. That's part of the price. If you want to have constitutional protections for suspects, sometimes innocent people, you're making sure innocent people don't get convicted, but along the way, some guilty people are going to walk. That is part of what happens here. It's a question of, is it valuable enough to pay that price? In the case of Miranda, they retried him without the confession, and he was convicted. So he did end up going to jail for the crime. All right, the last area I want to talk about is the right to privacy, which the Warren Court took several steps in the direction of. And the first case to talk about all goes back to birth control. As I mentioned, I think a week ago, in 1960, the FDA approved the marketing of birth control pills for married couples. By 1964, 1/4 of the married women in the country under the age of 45 were taking the pill. 80% of American adults thought birth control should be available for people who wanted it. But 30 states made getting birth control difficult, if not completely illegal. One of those states was Connecticut. And after the FDA approval, the Planned Parenthood Clinic in New Haven began dispensing the pill to married couples with a doctor's prescription. A Catholic neighbor complained. Much of the opposition to birth control law, birth control in the 1960s came from the Catholic Church and politicians who relied on Catholic votes. So a Catholic neighbor complains. Estelle Griswold, she's the director of the clinic, she gets charged, and the doctor who wrote the prescriptions gets charged. They were convicted and fined $100. The justices voted 7-2 that the law was unconstitutional. But William O. Douglas had real trouble explaining to you why it was unconstitutional. And there's nothing, the word privacy doesn't really appear, in the Bill of Rights. Douglas he cited cases involving other sorts of things that people are allowed to do. There was a case that said the state can't prevent you from teaching a foreign language. There was a case that said the state can't prevent you from educating your kids at Catholic schools. There was a case that said you can't force children to salute the flag. There was that case involving the NAACP and the freedom of the privacy of members in the NAACP. And then he starts rattling off amendments. There's the First Amendment, which protects speech. There's the Third Amendment, which protects your home from having soldiers sleeping on your sofa. There's the Fourth Amendment, which protects you from unreasonable searches. There's the Fifth Amendment, which protects you against self-incrimination. There's the Ninth Amendment, which protects all sorts of things that aren't even listed. He's just throwing things up there on the wall, hoping something sticks. And then he to try to pull it together, he says what's really wrong here is that the state is interfering with the institution of marriage and the privacy of marriage. Irony, since Douglas had already been married 3 times and was on his way to getting married a 4th time, but who cares? Would we allow the police to search the sacred precincts of marital bedrooms for telltale signs of the use of contraceptives? The very idea is repulsive to the notions of privacy surrounding the marriage relationship. Hugo Black dissented, and he said, "I like my privacy as much as the next person does, but I am compelled to admit that the government has a right to invade it unless it's prohibited by something specific in the Constitution." And Douglas hadn't really been able to figure out what that was. So Griswold hangs out there. If you read, scholarly literature about Griswold, it really doesn't. It's one of the most creative and most criticized decisions in Supreme Court history in some ways. The next step in the right to privacy happened a few years after Warren retired, but I have to end here, and it's Roe v. Wade. Because what happens then? Early 70s, abortion is legal in only a handful of states. Norma McCorvey, there she is in the upper left, she is a single woman in Texas. She's pregnant again. She wants an abortion. Abortion is illegal in Texas. She learns about public interest lawyers, Linda Coffey on the left there and Sarah Weddington. They were looking for someone to help them with a test case to try to challenge the Texas law. McCorvey meets them, and they represent her, and they sue Henry Wade. There he is. He's the Dallas County District Attorney, the person in charge of enforcing the abortion law in Texas. Now, while the case was pending, McCorvey couldn't get an abortion. She ended up having the baby and putting it up for adoption. But the case continued. And by a 7-2 vote, the justices struck down the Texas law. The opinion was written by Harry Blackmun, who had recently been appointed by Richard Nixon. He did something much simpler. As I mentioned, Douglas couldn't figure out how to explain why the birth control law was unconstitutional. Blackmun keeps it simple. There's the Due Process Clause in the Fifth Amendment and the 14th Amendment protects liberty. They can't take away your liberty without due process, and liberty involves something as basic as a woman's private choice to have an abortion. That, as Blackmun puts it, is inherent in the liberty that due process protects. He got creative, and all right, so does that mean every abortion law is unconstitutional? No. He invented the trimester system, that states can't regulate abortion at all in the first 3 months of pregnancy. They can impose reasonable regulations in the second 3 months, and they can prohibit abortion in the final 3 months unless the procedure is necessary to preserve the mother's life. The immediate effect of that law was to strike down, the decision was to strike down anti-abortion laws in 46 states. Okay, so I need to wrap up. Thank you all for being so patient. The Warren Court. If you go on Amazon, you can find books about it if you're interested. As I said, it's the only period so far where the Supreme Court was more liberal than mainstream public opinion. Even though most of the justices appointed to the Supreme Court in the past 50 years have been very conservative, most of the big Warren Court decisions are still on the books. The criminal justice decisions, Miranda's still there. They created some exceptions to it, but the exclusionary rule, the Miranda warnings, those are still there. The school prayer decisions are still there. The one person, one vote rule for state legislatures is still there. A few things have changed. The Supreme Court no longer takes seriously the idea that the Voting Rights Act matters. They've just, it worked back then. We don't need it any longer. It doesn't really matter what the states do at this point. That's how the current Supreme Court looks at things. And of course, it took them 50 years, but Republican presidents and the people they appointed finally managed to overturn Roe v. Wade. So, closing question, will the Supreme Court ever have a liberal majority again? I'm not betting on it in my lifetime, and I just had another birthday, so my lifetime is advanced. Who knows? But, there are the what might have beens. If Hillary Clinton had won,
Trump wouldn't have had 3 appointments. Things would have changed a great deal. If I'm Alito and Thomas, they're getting on in years. They're going to retire and let Trump replace them. They're not going to I assume, run the risk that a Democrat will win the next time around. So will we ever have a liberal Supreme Court again? I'm not betting on it. In any event, thank you all for listening. So on Thursday at 2 o'clock, we'll talk about 1968. Won't that be fun? Thank you.